So I'm just going to start by introducing Professor Hal Boyd. He's an associate professor of family law and policy at BYU. He's previously ran the opinion pages at the Deseret News and has written articles and essays for numerous venues, including The Atlantic, the National Review, the Weekly Standard. He's also the author of the book Psalms of Nauvoo and Are Christians Mormon? And most recently, for the College of Commonwealth, he is a graduate of Yale Law School and BYU, and he continues to teach courses in philosophy on the philosophy of religion. So very grateful to have Hal Boyd with us this evening. Anna, why don't you introduce our next speaker?
Thank you. As a journalism student, I'm really excited to be able to introduce Kelsey, and I really enjoyed getting to read some of what she's written. Kelsey is a national religion reporter at the Deseret News in Salt Lake City, and she covers the intersection of faith and politics, tracking the Trump administration's religious freedom policies and high-profile Supreme Court cases. And if there's anything you'd like to add to that bio, Kelsey, feel free. I know there's a lot more that can be said.
Oh no, that was great. Thanks again for having me.
We're so excited to have you here.
Excellent. So I'll go ahead and finish off by introducing our final panelists. Tanner Bean is an associate at Fabian Van Cott and focuses on employment and litigation. He joined that Salt Lake City law firm after completing a clerkship at the Idaho Court of Appeals for the Honorable Molly J. Husky. Tanner has particular experience in the intersecting areas of religious and LGBT discrimination found in workplaces, housing, public accommodations, and education. He's a graduate with honors from BYU's J. Reuben Clark Law School, and he served there as the president of the trial advocacy team, symposium editor of the BYU Law Review, and research fellow and student management board member of the International Center for Law and Religion Studies. He also studied, received his undergraduate degree at BYU in English, and he currently serves with the J. Reuben Clark Law Society's Young Lawyers and Student Chapters and Religious Freedom Committee, and is the founder of the Workplace Religious Accommodations Database Pro Bono Project. Tanner has also been someone who's worked a lot on, as I mentioned before, laws dealing with religious freedom and LGBT rights, and specifically has presented on those topics to a variety of communities. So we're really glad to have his expertise here on that and on religious freedom issues in general. So I think, Rachel, unless there was anything else you wanted to cover, we can turn the time over to Professor Campbell.
All right, I guess that means that's my cue. I really appreciate the opportunity to moderate this discussion. I've had an opportunity to know Kelsey over the years. She's come to my media and religion class several times, and Hal I've known at the Deseret News, and Tanner I'm getting to know, and I'm kind of known from afar. So, and as a moderator, I know that you've had an opportunity to look at some of these questions, but I'm going to add one at the top of this issue, just it's right out of the news. What do all of you think about the announcement of Pope Francis supporting civil unions? And what kind of impact might that have on religious freedom issues? I'll start with Tanner.
Sure. So I think a lot of people have been shocked by that announcement. I am not particularly shocked by it. I think the way that, the Church of Jesus Christ of Latter-day Saints has handled, same-sex attraction and civil unions and same-sex marriage in the United States is somewhat similar to what, the Vatican has come out with, blessing, in society, in, democratic societies, the same, these unions, but not necessarily adopting it as a matter of, church policy, changing the policy to reflect that. So I think as a matter of religious freedom, I think it's actually good. It de-escalates some of the conflicts that we perceive to be the case, as if, LGBT rights and religious freedom are going head to head and you only get one or the other. And so I think that can do some good for the perception of religious liberty.
Yeah, I mean, I guess when I heard about it, I said it has some similarities to the Utah Compact. And so I thought it was fascinating. Hal Boyd, what's your reaction? Again, this is a question off the top of my head out of the news, but what's your reaction?
So my initial reaction was similar, that this might potentially broker the ability for compromises on these issues, particularly with regard to issues surrounding the Equality Act, the potential of the Equality Act passing Congress, which is a piece of legislation that would broaden LGBTQ protections. We'll probably have a chance to talk more about that. And so that's where initially my mindset went, is, there might be some potential for compromise there. As I've seen some of the reactions from actual archbishops in the United States and in North America, I guess I've reined that in quite a bit, and used some of the statements that have kind of been documented on archbishops' websites or by reporters include, and I'll quote, clearly the Pope's statement contradicts what has been long-standing teachings about the Church on same-sex unions. Another archdiocese in New York put out an official statement that says, quote, the Holy Father has plainly erred. And lastly, Carlo Maria Vigano, Archbishop, said regarding the Pope's statement, he ought to be guiding the bark of Peter and has chosen to side rather with the enemy in order to sink it. So I'm not as bullish that the entirety of the Catholic faith, particularly in the United States, is fully on board with the Pope said. And as more information comes out, it seems as though those remarks, to give some context, were part of a documentary, sort of impromptu, off the cuff. And so maybe shouldn't be taken as maybe an official position of how politically the Catholic Church will act. With all of that said, it can't help but to broaden cultural attitudes, particularly among the laity and even among the clergy in some regard. And so I am hopeful that there'll be a thawing. And my personal feeling is I hope there is a thawing and an openness among Catholics and the Catholic faith. I think there is among many Catholics, but the Catholic clergy toward more compromises on these particular issues.
Now, Kelsey, you've been taking a break, and a much needed break probably. So I don't expect you to know, you wouldn't have probably been reporting today about all of these issues, but just from an observer over time, what would you say might be the implications of this from a journalist perspective?
Well, it's funny that you say that, because one of my editors called yesterday to pick my brain for ways to cover it. So I'm not totally off the clock, even though I'm supposed to be. But I just wanted to mention that what was fascinating to me was, my reaction was, why does this have to be such big news? Why can't it just be, okay, the state can do what it wants to do, a country can do what it wants to do, and we in the church will continue to have our policies and have our teachings, and we will hold to that line. But I think it's just, I thought more about it, and I sort of said, as Hal noted, with those statements coming out from archdiocese, with even leaders from other denominations saying that the Pope was wrong, how could he say something like this? It really sank in for me that the risk of a leader like Pope Francis saying that civil law should change in this way is that it just opens up the church to some new situations legally that are tough, that we're going to talk about tonight. That when same-sex marriage is legalized, you suddenly get yourself into a lot of difficult situations with should religious adoption agencies adopt to same-sex couples, for example. So it just creates some new legal challenges. And I think that's part of why there's such a strong reaction that says, like, Pope Francis, how could you say that? You're just creating a huge headache for us.
Well, isn't that, but that's, at least in Kelsey's world, that just makes, that keeps you fully employed, because so many news stories are going to come out of this. So given that fact, we talked about an external influence of a major world faith leader making a statement. Let's focus a minute on governmental bodies, or the branches of government. And this is maybe a trick question, but for Tanner, I'm going to start with Tanner and say, as you look at the executive, the judicial, or the legislative, which branch of government has had or can have the greatest impact on religious freedom policies?
That's a great question. And depending on when in history you ask that question, the answer is probably going to be different. And the reason for that, just to give a very high-level perspective, is that our First Amendment has some very solid protections for religious freedom. But the way that those words in the First Amendment have been interpreted by our Supreme Court has varied over time. So in 1990, there was a big shift that left the First Amendment, in many people's opinion, a lot more watered down. So you couldn't seek as much religious freedom, protections through the courts as you might have been able to before 1990. And because of that, another player stepped into the game, and Congress stepped in and passed what's called the Religious Freedom Restoration Act, kind of saying, no, we do need a really vigorous standard in the First Amendment. And so essentially what they did is they took what the First Amendment used to be like and interpreted what it used to be like and put it into a federal law. And that's the Religious Freedom Restoration Act. So, Congress took a big chunk of the power or the protection of religious freedom that way. And I think something that we see now, several years down the road from even that action, is that the executive branch is also stepping in more frequently, as to either preventatively protect religious freedom in very broad ways, or to step back and say, religious freedom is a value that is conflicting with other values that we find more important, or at least as important. And so making a policy decision that we're going to win out here, or we're going to let this other value win out for a second. So the answer is it depends, which is a classic lawyer answer. And so apologies for that. But those are kind of, the big picture tickets here. So it depends what time you're asking, kind of who's in the game, and also where you live. And we can talk about that a little bit later if you'd like.
I like that. No, that's great. We need to help our students that are listening to understand that it depends. Kelsey, you've had the opportunity to cover the Trump administration in particular and the Supreme Court and the kind of this interplay. The Trump administration has taken on some initiatives, as I see it, and you can correct me if I'm wrong, to expand in some areas, to move into some areas where the Obama administration had restricted some issues. Where do you see from your, just say the Trump administration era, what do you see has happened with religious freedom? And I'm sure that's a big question, but maybe we can focus on a few things.
No, this has been a fascinating few years, and I'm really glad that Tanner got to that at the end where he said we've seen a lot of executive action recently, because I can't tell you how many stories I've covered that are just like President Trump put out this executive order on X, Y, or Z that matters to religion. And it's because he was being very proactive in the absence of congressional activity on this topic, with sort of saying, I'm standing up for faith groups. I'm ensuring they have these protections. We're in a difficult moment right now after the legalization of same-sex marriage. And so the Trump administration was trying to be very, I don't know if aggressive is the right word, but they were just saying, hey, we got your back, faith communities, we're going to do this. And I come from a perspective that the Obama administration wasn't trying to attack religion or leave faith communities out in the cold, but they were just sort of taking religious issues in maybe an equal playing field with a variety of other topics, like just saying, let's watch out for faith as we accomplish these other goals, but sometimes made decisions that angered a lot of folks. So as they worked on healthcare, for example, with that rule about having to provide contraception, that was incredibly upsetting to Catholics, for example. And so that was a place where Obama and his administration was saying that our goal of having this type of health coverage outweighs religion. And I don't think the Trump administration has ever said that X, Y, or Z outweighs religion. They've really put it front and center. And the way I've actually written about it in some recent stories about what is the Trump administration's sort of legacy after 4 years is just, it's almost like a you get to win all the time as a religious person. Like, we are going to hold up your rights. The First Amendment is the top amendment for us to care about. And I'm not saying that's good or bad. It's just that that was the attitude that administration took. And that's how they've really supported a lot of their key religious voters that supported his road to the presidency and that are continuing to be valuable in this current presidential campaign.
Let me just change up that question just a little bit for Hal. What do you make of our current situation as with regards to religious freedom domestically in the United States? Where do we stand?
So I would characterize it as a rather precarious situation, and I'll let me back up to try to explain that, because not just because we're coming up on election, but recently I went through with a team at BYU a data set that looked at about 11 different countries, 16 or so thousand survey participants, and it broke down sort of the religious demographic of these various different countries. In the United States, in contrast to their sort of European peer Western countries, the United States has a very balanced mix of religious and non-religious demographics. So if you were to go to a country like France or even the UK, you have a much smaller minority of highly religious individuals. So the vast majority of citizens would be characterized as secular or having very little religious participation. Whereas the United States has this balance. And in fact, its composition between highly religious, nominally religious, some religious involvement, but nothing really steady, and then no religious at all, no religious activity at all, that breaks down to about a third, a third, and a third. And and we're, you know, a large country, and so we have about 85 to 90 million people who are highly religious, who go to church every week. That's a lot of people. In fact, it's more people than, you know, than the UK. So the entire country of, you know, the entire United Kingdom, we have more people who are highly religious just in this one country. Now, by the same token, we have about the same, slightly more of those who engage in no religious practice. And exacerbating this situation is the fact that the people who are highly religious tend to live in the middle sections of the United States, more rural areas, the South, the Midwest, the Mountain West. So they're sort of segregated from those in the urban cores, the coastal urban cores, who tend to be more secular or participate in less religious activity. So to get to the question, I know that's a lot of demography that is probably had multiple people already sign off the Zoom call. But to get to your question of what is the status of religious freedom in the United States, because of that unique composition, you have very strong, fervent individuals of faith, and then you have very strong, fervent individuals of no faith, and they don't quite understand each other. If they do interact with each other, it's typically on social media, which isn't maybe the best way to introduce one's ideological commitments or worldview to another. And so as a result of this, both sides have an immense amount of mistrust for the other side. And so what occurs is when there are large victories, so to speak, for one particular group, such as in the Trump administration, where you have, you know, we're going to protect you all of the time, if power shifts over to those who are maybe represented by a different demographic, namely the non-religious, no religious participation in the coastal urban cores, then that group is going to exact the same kind of regime onto the almost the flip side, the complete opposite. And so as a result, it makes the situation very perilous. It makes the situation volatile. So one cannot expect to have their First Amendment rights protected from one regime to the next without any hiccups. They're always on the ballot, right? And so this ratchets up the political stakes of every election, or ratchets up the mistrust of the other side, and so the desire to hold on to power because one fears what the next regime will hold. And so my overall assessment of religious freedom in America is it is perilous, even though we're currently have a regime that seems to be quite friendly to it, and even a court, a Supreme Court and lower courts that may be more favorable to the First Amendment. that situation seems perilous because of that seesaw kind of situation that we see in the United States that's largely based in demography.
Fascinating. We've asked our panelists to kind of take on the three branches of government. Tanner has been asked to look at the legislative. So we're going to start with Tanner, and I welcome the other panelists or any of our members to ask him questions as we go through this. But I do have a first question. How is religious liberty protected by Congress? And maybe just do an assessment of where we're at with that Congress created legal structure of religious liberty or freedom, however you want to, what term you want to use.
Sure. So as I mentioned before, in 1990, when the Supreme Court's interpretation of the First Amendment shifted, Congress came together as a very bipartisan effort, very few dissenting votes. Clinton signed the bill, and we came up with the Religious Freedom Restoration Act. And essentially what it says is that if you are a religious person or organization and the government burdens your religious freedom as they're pursuing some other goal, maybe it's non-discrimination, maybe it's environmental protection, maybe it's, pursuit of who knows what, right? But incidentally burdens your religion, you get to go to the courts through this bill that Congress passed and ask the courts to give you an accommodation, an exception, an exemption, or something like that. But you're going to have to show that the government's interest that they're trying to promote, in environmentalism, in something else, that it's not very compelling. Or you might say that there's another reason, there's another way that they can protect that interest that they're pursuing without burdening the religious practice at issue. And if you can do that, then you are likely to get an exemption. So that has been a pretty popular regime. There's been a lot of support for Religious Freedom Restoration Act at the federal level for a long time. However, that has eroded significantly in the past, I'd say, decade or so, as different interests have seen to be possibly in competition with religious exemptions. And so Congress's role here is becoming increasingly important, and folks in Congress, some are looking at revisiting the Religious Freedom Restoration Act, or at least altering it in a way that would make the balance between, rights like LGBT non-discrimination and other rights simpler to achieve in their view, right? So a good example is the Equality Act, which Hal mentioned. And that act, while expanding, I think rightly so, non-discrimination protections to people in the LGBT community, in housing, hiring, public accommodations, etc., that bill actually rolls back sections of the Religious Freedom Restoration Act, where, for example, a non-discrimination law clashes with someone asking for an exemption. So, the most high-profile example of this would be the Masterpiece Cake Shop case, where the Christian baker didn't want to bake the cake. But the non-discrimination law in place said you need to serve all people, including those that are LGBT. The Equality Act would make that clash between, the Religious Freedom Restoration Act that's seeking through the courts for an accommodation, an exception from that rule, a non-starter. So you couldn't seek it. You might be able to use the Religious Freedom Restoration Act for something else, but you wouldn't be able to use it in that situation. So that's one way that things are in motion in Congress with Religious Freedom Restoration Act and other bills. I should mention, yeah.
Can I just ask you then, we have a good senator, a good representative from Utah who's put the Fairness for All Act forward. And again, that's part of this debate. What do you think about where's that stand? Obviously with the Democrats in control in the House, it may not have much of a chance to being passed.
Right. So I'm a firm advocate for the Fairness for All Act. It is modeled off of what the law that Utah adopted in 2015 called what some people colloquially calls the Utah Compromise. And essentially what that law does is it says, look, we have these interests in LGBT non-discrimination. We have these interests in religious liberty. Let's settle them in an even compromise, that gives us all more than what we would hoped for in a drag out fight in the courts, right? And so they achieved that. I'd say that the compromise in Utah has been very successful. The bill, the law has not been challenged in the courts. And I'd say, you know, public opinion in Utah has increased substantially in support of LGBT non-discrimination. Just last year, I believe, there was a poll conducted, and Utah is either tied for second in the most supportive for LGBT non-discrimination protections in the country, which might shock a lot of people. You know, I think we're tied with Vermont or something, right? I don't know anyone from Vermont, but you know. But as far as the Fairness for All Act goes, it's kind of the big brother of the Utah Compromise. It takes what the Utah Compromise did to the federal level and addresses even more issues. So the Utah Compromise mainly hit on housing and hiring. And the Fairness for All Act goes beyond. It goes to education, it goes to public accommodation, it goes to some abortion procedures, it goes to tax-exempt status of religious organizations. So it really tries to address every big clash point that we see in the news and kind of resolve it in a way that would calm things down for the culture wars. And I think it's a very intelligent proposal. It might not be perfect, you know, we can tweak it a little bit, but the trouble it has politically in Congress is we're in a place where there's polarization on both sides. So Chris Stewart from Utah that put forward the bill, I think did so very courageously and has faced not criticism only from the Democratic Party, but also from his own party for advancing something that is any sort of compromise. And, you know, the other side might say, you know, coming from the LGBT's perspective, that it's not enough or doesn't guarantee enough, or it doesn't ratchet down the Religious Freedom Restoration Act so that, you know, one issue prevails in certain circumstances. So that's kind of where we're at. Those two, Equality Act and the Fairness for All Act, are those vying for attention for congressional action.
I mean, would it be fair to say, at least at this point until after the election, there's not much chance of really any of those bills moving forward, maybe not even till the new term or something? If they
I would say, yeah, I would say that's fairly likely. I was on a call with a few congressional staffers a week or two ago, and they said that particularly in the season, you know, those are some hot button issues. You know, people of faith want to hear that their faith is protected by the next candidate. Similarly, people that belong to the LGBTQ community want to make sure they can, you know, go into a restaurant and receive a burrito just like everyone else. And so these, you know, issues are big fundraising issues. We see, you know, policy groups that do a lot of fundraising on this. And once you settle something in a compromise like this, the need for fundraising and the need for organizations to push so hard on those polarized issues goes away. So it's difficult to depolarize these things unless we have some really strong action from the middle, or some really strong, you know, action from courageous, you know, representatives like Chris Stewart.
Interesting. Well, we are days away from, I think the last day to register to vote is today or tomorrow. We're days away from a major presidential election. Kelsey, reflect for us a minute about what's happened. We've talked a little bit about it, but reflect maybe more specifically about what's happened over the last 4 years, maybe even a few examples about what's happened with the presidential policy with religious freedom.
Well, as we already sort of set the stage, from the beginning, President Trump was out to strengthen the protections available to religious communities, and he did so proactively. And by that I mean, as Tanner was talking about the Religious Freedom Restoration Act, that was always there for groups to speak up and say, this federal policy is burdening me in some way, and either ask for a change directly with the government and maybe cite RFRA in the process, or take it to court and say, I need this change in order to live out my faith. Well, for the last 4 years, the Trump administration has been proactively saying within the policies that they're putting forward, within the executive orders, that because of RFRA, because of the Religious Freedom Restoration Act, we're going to do this. We're going to create this exemption for faith groups. This doesn't apply to religiously affiliated government contractors. For example, if they get this government funding to do something, they don't have to obey certain non-discrimination rules. Or when there were those loans being handed out because of what Congress interested in light of the pandemic, the paycheck protection loans, there was a move made in some of the rules that said if you're a religious organization that receives that stimulus money, you don't have to obey the same types of regulations in the way you spend it, because we know that you're sort of unique in your religious needs. So throughout sort of all levels of what the Trump administration was up to, they were looking out for these religious actors. And in specific policies, like they stepped in to protect a religiously affiliated adoption agency to say you don't have to lose your government contract if you won't work with non-Christian or same-sex couples. There was action on prayer, for example, I think on like the National Day of Prayer, where they're saying you should be safe to pray in school. They're saying we're going to stand up for pastors who want to talk about politics from the pulpit. In some cases, these things were already taking place and were already allowed, and it was just sort of a symbolic act for the president to say we support you. But in other ways, this was very significant that they were always sort of taking that legal step to say we're going to beef up protections. And then the other thing I just add, I know we're talking mostly about domestic issues, but the Trump administration has been very active in the international space, putting more and more resources into protecting religious groups overseas. But there has been some difficult situations with, or difficult tension around there, because at the same time as they're working very hard to support religious groups around the world, they're not bringing in refugees in the same levels that we have in the past. And I think you can say the same thing domestically, where they're working very hard on certain issues that matter to more conservative faith groups, but then they still sort of leave Muslims hanging out to dry sometimes, or they create tension for other religious minorities. And so it's always sort of been, we support religious freedom, rah, rah, rah. But then there's some people of faith that say, yeah, but your definition of religious freedom is a little different than mine.
Yeah, I mean, I think the cynics might say that Trump was aiming this toward an evangelical base and kind of hitting their issues that mattered most to them. I don't know whether you agree or disagree with that assessment, but I've certainly heard that.
Oh, certainly. That's where I get nervous about what the future will look like, no matter who wins in November, sort of no matter what happens with the balance of the Senate, for example, just because not only are we becoming more polarized, where maybe the Democratic Party is moving more left, the Republican Party is moving more right, but we're just operating under a completely different idea of what religious freedom is supposed to be. And so I get these press releases with statements that I can't even put next to each other in the article, because they just would make no sense next to each other, because one person is saying this Supreme Court ruling is hideous and horrible for religious freedom, and the other person is saying this is exactly what religious freedom is supposed to be. And so it's just a very difficult time. But it's also, I mean, you already made this joke before, where you're sort of like, it's a great time to be me reporting on all this, and it is, because it's juicy. There's always something to talk about, and I could write entire articles with just like 100 different people quoting what they think religious freedom is, and it would be completely different.
So, I mean, that's probably part of, and the students that are among us here is kind of figuring out what is that definition. And you're right. I think every particular different groups have different definitions or different agendas.
Well, and I'll add one more thing, which is that there's a tension point about what a Biden administration would look like on this.
I wanted to talk about that, yes.
Yeah, and there's a lot of folks that are saying, there are people of faith who are saying, I don't really like what President Trump is all about, except on this issue of religious freedom, that it was so important for him to be in office, especially after the Supreme Court legalized same-sex marriage in 2015, to have a president that would sort of beef up these protections for folks who still believe that marriage is only meant to be between one man and one woman. But there's Biden supporters that say, you're being crazy. Biden supports true religious freedom. He's a friend to minority faith groups. He is a very strong Catholic himself and understands how difficult it can be sometimes to navigate the public square as a person of faith. And so he's going to look out for you. And I interviewed a Latter-day Saint, for example, who said, Biden's values are my values. And he knows the true meaning of religious freedom, and he won't sort of privilege one type of Christian over other people of faith. So that's what I'm saying when I say that we're all operating with these different definitions. there one voter will say that Biden is horrific to religious freedom, and another voter will say that Trump is horrific for religious freedom, and nobody can come to an agreement. And so, we've been talking about, it's going to be a rough next 4 years, no matter who wins, because everybody out in America doesn't sort of agree on what we should be doing on this issue.
Well, if there's probably any major flashpoint where all of these issues have converged, it's the nomination and potential confirmation of Judge Amy Coney Barrett. Hal, tell us, first of all, where's the judiciary at on religious freedom, and maybe give us some insight about this whole confirmation process that has in some cases raised religious tests and other kinds of things. But let's start first of all, where's the judiciary at currently? Where are we at with religious freedom as far as the judiciary goes?
Yeah, so let me just first discuss the judiciary a bit, and in contrast to the legislative branch. So we all know, we've understand the Constitution, that there are these different divisions and a separation of powers, and the judicial branch is a separate charge from the legislative branch. It is not where the Constitution locates lawmaking power, but law does come out of the judiciary. So how does that work? Well, the judiciary, and again, I'm going to have another droning lecture here that's going to cause people to leave. But the judiciary, when we became a nation, the United States of America, we adopted something called the common law, which was a package of laws that were developed by judges over time. Something would happen, someone would make a judgment on it, something else would happen, there'd be a land dispute between Blackacre and someone else's land, and who owns this and who put whose cows there, these disputes going back hundreds of years, time immemorial. And over time, these judges made judgments, and some of these similar judgments got grouped together. And then you'd have a law, which is kind of an abstraction, right? So you'd have instances, just like the same concept of mercy. How do you understand mercy? Well, that's a word, it's an abstraction, but it comes from instances that you've seen of merciful behavior. Or charity. You understand these concepts as they're instances, and then they become an abstracted understanding of what that is. So that's how the common law works. There are these instances, and over time, judges made these rulings, and you could kind of package them together and be like, well, that's a law. That's how we judge on this particular issue with regard to a land dispute. Okay, so now fast forward to today. So the judiciary does make law, and as Congress became more intractable on issues of deep importance to religious individuals or LGBTQ individuals or others, and it no longer became good politics to compromise on those issues. It's much better to fundraise off of them, or it's just not a good issue for you if you're a politician. You just don't want to have to deal with it. And so very little gets done with regards to these issues in Congress. So the Religious Freedom Restoration Act was what, 1993? Maybe it cannot have. Okay, so that's a long time ago. So lawyers are smart people, lobbyists are smart people, groups and institutions are smart people. And so they started to see something that we call in the law venue shopping. So if Congress wasn't going to pass laws, maybe you could get the policies you want, maybe you could get them through the judiciary. Maybe that actually might be a smarter way to get laws that are favorable to you as an individual, your group that you're lobbying for, through the judiciary. Because although they're not ostensibly making law, we know they actually do make law. And especially if you get a Supreme Court precedent, that's pretty powerful. That's saying that we interpret the Constitution to say we're for this, or we're against this, or this is okay or not okay. This is constitutional or not constitutional. And so I would say in the latter half of the 20th century, and particularly now, there's a broad consensus among those who are hyper attuned to these issues, both on the right and the left, that boy, the judiciary, that you can't really get Congress to agree broadly on these hot button issues. but maybe you can sneak by if you've got the right court to agree with you on a particular issue. And so the judiciary has become probably the most active branch of government in deciding these very contentious issues related to religious freedom, LGBT rights, etc. And so how has the judiciary done in this role? Well, I do think that they've, over the summer, they have tried to strike a fairly balanced a tone approach. They ruled in the Bostock decision, which extended non-discrimination protections under the Civil Rights Act for LGBTQ employees. But on the other hand, they ruled in another case, two cases that were merged in California with regard to parochial schools, Catholic schools, that the definition, the ministerial exception, which is an exception from those Civil Rights Acts. So I should turn to our other panelist, Tanner, who knows a lot more about employment law. But essentially, if you indulge me, and Tanner can correct me, but essentially the ministerial exception says that if you are a minister, you are exempt from the Civil Rights Act. So you may not know this, but essentially a congregation has broad freedom to choose their minister, and they can discriminate. They can discriminate in choosing their pastor, in the sense that that is such an intimate relationship to the congregation that there's broad allowance to say, look, we don't think that this person's the right religious tenor, or we don't think this person. You can discriminate broadly on who your pastor is. Well, the court ruled both that extending LGBT protections in employment and non-discrimination, but then in these other rulings, they said, we're broadening that ministerial exception to include religious teachers. So if you are a teacher in a religious school, or maybe even a professor in a place like BYU, where teaching religion is integral to the mission and the aims of the institution, that you may fall under this kind of ministerial exception. So I say that the judiciary, in that sense, the Supreme Court, has tried to strike this balanced approach of trying to navigate these competing rights. Now, we would characterize sort of LGBTQ rights as emerging rights, and the First Amendment rights are certainly settled rights that are written into the Constitution explicitly with long precedent. But nonetheless, the courts are balancing these rights, and so we think of the scales being balanced, right? That's what courts do. That's what judges do, and that's what you see in the Supreme Court. Whether they've got every single thing right or wrong, I'm not going to weigh on that. But you do see an attempt among the judiciary to navigate these and balance these. Most of these issues ought to be handled in the legislature, my opinion. But because the legislature hasn't been active in this regard, you see a lot more, even people essentially, I don't want to say fomenting cases, but they look for particular cases that may be ripe for a decision on a particular issue to send that up to the Supreme Court. So you see a lot more of that in the judiciary than maybe you did decades ago, when our Constitution was perhaps a little bit more properly balanced in the allocation of duties. So,
just I wanted to ask you one question, then we want to go to Q&A with the folks here. But so the media, which I happen to be part of, would have us believe that Amy Coney Barrett is going to bring a court into a much more conservative realm, and the possibility of overturning things like Roe v. Wade. Hal, what do you think? And it looks like she's probably going to be confirmed. What do you think is going to happen?
Well, certainly just from the numbers, you're going to have six appointed judges from Republican presidents versus 3 appointed by Democrats. And so people judge based on that I would say that, based on what Amy Coney Barrett has said, based on her mentor, her being mentored by Antonin Scalia, that she's going to be largely an originalist, which means she's going to try to interpret based on the original intent of those who either ratified the Constitution or with regard to legislation, the original intent of those who passed the legislation. So I think that's going to be her governing philosophy or judicial philosophy. And I would say that in terms of her religious views, those can only enhance her. I think this is my personal opinion, but I think if someone is truly a devout religious individual, when they take an oath to uphold the Constitution and to execute a justice, equal justice under the law, that they're doing that in the presence of God. They're doing that before God. And in fact, Judge Griffith, a Latter-day Saint judge, now retired, who was formerly the general counsel of BYU, testified on behalf of Amy Coney Barrett and gave this point. And I've had a few conversations with him over the past several weeks, in which, you know, we're both of accord that if you believe devoutly in God, then you're taking that oath quite seriously, because you'll be held accountable to your Creator of whether you fulfilled that oath to honor the laws of the land, to uphold the Constitution, to mete out justice equally, and to fulfill the oath of office. And so I think, with that regard, I think Amy Coney Barrett will be uniquely qualified and uniquely suited. And I think we ought not to be scared. Certainly those who are highly secular, like I said, you know, a third of the country are going to be very scared of that, but they ought not to be, because in fact, that's the greatest assurance. A highly religious individual who takes that oath is perhaps the greatest assurance that they will live up to it.
I've got a couple of, at least one question here on the chat bar. I'm going to ask if Anna Briner won't give this question. And I think Tanner and Kelsey and Hal, or whoever you want to give it to. Anna, do you want to talk about your question about the, what is it, Fulton versus Philadelphia case?
Yeah, so there's some speculation, and this question's open to anyone who'd like to comment, but with the upcoming Fulton versus Philadelphia case, that there could be a shift in free exercise interpretation from the 1990 Smith precedent to maybe something else, that Smith might be revisited or even overturned. And so I'm curious, if that were to happen, do you think it would strengthen protections for religious exemptions? Because right now we have RFRA on one hand, federal law that you can sue under and win different things. And then, but if you take the same claims under the First Amendment with the Smith precedent, you're kind of out of luck. So do you think that would increase protections? And what other implications might there be in overturning Smith?
I can take this one to start off, if that's all right, Kelsey and Hal.
Please.
So that's a great question. And I want to share my screen real quick and show you a map that might help us out a little bit with what I think that would do. So it looks like you might have to enable me here to do that.
So I think Brady's in charge of the show. Brady, can you let him share his screen?
Well, while he does that, I can get going. So I think what the Smith decision is that's that 1990 decision that I talked about. And okay, I got the screen up here. Can everyone see that?
Yes.
So what the Smith decision did was, force Congress into a place where they had to make this Religious Freedom Restoration Act. The trick was that a few years after the Religious Freedom Restoration Act was passed, it was declared unconstitutional for part of the application of the act. So it couldn't apply in any of the states. So if there was a federal actor, or if the federal government burdened your religion, then you could use the Religious Freedom Restoration Act, go to the courts. But that meant that if your, county mayor or your state, board of education or something like that burdened your religious freedom, somehow you were going to be out of luck as far as how the First Amendment goes. You couldn't use the First Amendment necessarily to get where you needed, and you couldn't use the Religious Freedom Restoration Act either. So what happened is that a bunch of states passed what are called, mini RFRAs is what we like to call them. So the ones in green here you see all have a law that's very similar to the federal Religious Freedom Restoration Act. And there are a number of states that, instead of passing this in their legislatures, have done this in their judiciaries, essentially, interpreting their state constitutions to require the same thing that RFRA requires, or the same thing that the First Amendment used to require before 1990. But there are lots of states, like you can see in the gray areas, that don't have either of those things. Utah happens to be one of them. We have kind of a different framework, that Utah Compromise framework that we talked about. So the main point I want to show with this map is that if we did switch back and we overturned that 1990 decision and went back to the original understanding or the Smith understanding of the First Amendment, all of this inconsistency across the states would go away. We'd come back to a federal standard that was unified, that could be used in the same way no matter where you live or who burdened your freedom, whether it was a state, local, or federal actor. So that's a big piece. I think there's a lot of speculation of whether in that case this fall, whether Smith in fact will actually be overturned. That would be a big move. I personally think that there's still room for legislative work to be done, even if that does happen. As Hal was mentioning, all these disputes go into the judiciary, and our judiciary is not built for compromises. It is built in a very adversarial way, right? And so we fight and fight and fight and fight, and then someone wins and someone loses, unless you decide to settle before everything gets really messy. But in Congress and in state legislatures, you can come together and on the most contentious issues, weigh numerous points, lots of different perspectives, and come out with a result that has a sense of justice for a lot more parties. No, not just a slam dunk win at the Supreme Court for one side or the other. So I think that will be important, even if Smith is overturned. But if Smith is overturned, I think we will see a lot of test cases that will come out and try to see, what this First Amendment really looks like again, right? All those cases that Hal was mentioning, people have been, boiling up and just waiting for the right moment to shoot them through the courts. So that's my take on that.
I just want to add that the legal system is also not built for speed. And so one of the tough situations we're in right now is that you're just in a constant holding pattern of how is this going to shake out? What rights do faith groups have? What rights do members of the LGBT community have? And so the benefit of going a legislative route is, again, you're not moving so much faster, but at least you're sort of operating on a more reasonable pace, that you're getting something done, you're moving things along, whereas courts are dragging out over multiple years, incredibly expensive process.
I would like to maybe just have each of our panelists just kind of give us some, where, just kind of from your perspective, where we're at and where we're going. And maybe we've already done that, but I'll just start with Hal and then Kelsey and then Tanner, and then we'll close it up at that point.
Okay. Well, I will use my closing statement to just address the question kind of that Anna had posed on the Smith decision. So just, I guess, a little bit of background on that for those who aren't familiar with it. The Smith decision is about related to peyote. And there were these, Tanner can correct me, or Kelsey, or anyone else. But what I recall is there were these individuals who worked for a drug abuse kind of correctional sort of group, and they decided to smoke some peyote, which of course has some intoxicating element. And there was a state law, I believe this case was in Oregon, that made that illegal, and they were fined, they were punished for that. The law, or they then, the plaintiffs, those who were accused of smoking this peyote or charged or whatever the specific circumstances were, they decided to sue on religious freedom grounds, to say that this is part of my religious expression, this is part of my religious worship as a member of the church. I think the Native American church is how I was characterized. And so this floated up, and it was actually the majority opinion when it was ruled in the Supreme Court was Antonin Scalia, someone who is, those who follow the courts think of as had been a very strong supporter of religious freedom. He himself was a devout Catholic who has a son who currently is a priest, a member of the clergy. And yet what he ruled was, he said that this prior standard with regard to religious freedom, which was that there had to be a compelling state interest to infringe on religious freedom. meaning that you really, as a state, you really had to have a great law, a really good reason to infringe on the religious freedom of a citizen. You had to come up with a really darn good reason. COVID might be one, right? You think of what's a really compelling interest that would say that you could curb on the religious freedom of an individual. And if you don't have it, it's unconstitutional as per the First Amendment, right? If you can't show me that compelling interest, it's unconstitutional. So what Antonin Scalia, who was kind of a law and order type guy, and he sort of decided to rule in the Smith case about peyote and say, you know what? If a state has a reason, and if the law is neutral, meaning it's not targeted directly at religious people, but it's sort of a neutral law and is generally applicable, applies to everyone, then the state can make a law that, infringes on your religion. And that's not a big deal. That's the state ought to be able to do that. And there's other cases, there's a case called Prince v. Massachusetts about a Jehovah's Witness couple and taking the child, they were actually the guardians, but taking the child to go out and hand out pamphlets. And they got fined because they said, you're violating child labor laws. And the court upheld that and said, even though it's really important to have religious freedom and really important to allow you to have the parental rights to take care of a child, the state can put in a law like that. And so that became the standard, saying you didn't need to have a compelling state interest. It just needed to be generally applicable and neutral. And so to Anna's question, I see it religious freedom going forward. I do think that will be changed. I think a lot of observers see that as maybe not been the best precedent on that issue. I think Antonin Scalia, from what I'm told, has sort of soured on that case. He's now passed, but soured on that case toward nearing the end of his life. And now with this Philadelphia or another case, and with the court composed the way it is, I think you'll see a shift back toward that. And to Tanner's point, that will change that map and make that more uniform. And so I anticipate that being a future move from the judiciary. I yield my time.
All right. Yeah, we're just a bit over time, but if Tanner and Kelsey, if you could just give us a short final statement, and then I'll turn it back over to Rachel to end this up.
I'll just say something really quick. I think it's really cool that you guys are involved in this club. And you don't hear the word cool associated with religious freedom that often. It's hard to explain to people, even in religion journalism, why I follow the issue so closely and why I've sort of specialized in it. But we're at such a fascinating moment right now on this topic, and it's only going to get more interesting as we learn the results of the election and sort of see what happens over the next couple of years. So stay invested and keep following this, and you can be cool like me.
And when Kelsey's back actively writing, follow her on Twitter and everything else to see her stories, right? Tanner?
That's right. I'll echo that. Kelsey and Hal put out some great stuff, so make sure to watch for it. I was just going to leave off with kind of a charge as we go into the election here for those, maybe undecided voters that do exist out there. I think this is an issue which right now we have an interesting ability to really weigh the candidates, right? If you go to both of their campaign sites, for example, they both have large issue pages about religious freedom, what they've done or what they're going to do for religious freedom across different venues, domestically and internationally, what they think that religious freedom is. And the executive, the president and, governors, state governors, they do have an impact on this. We've talked a lot about Congress, we talked a lot about the courts, but, the folks that are teeing up these big fights, either in the judiciary or in Congress, often are, executive policymakers who are interpreting laws in a way that perhaps they weren't intended, or, take them beyond their bounds of what they were intended to be, and then we end up in the courts, right? So this does have an effect, and your vote does count in those respects, especially as we get to local politics, local policies, and then local, executive members can really make a big impact. And that's also a place where you can make a big impact for good for religious liberty too. So that's my charge going out, is to weigh that issue, certainly in the choices you make.
Well, I'm gonna pitch it back to Rachel to kind of give a farewell and maybe give a plug for how to follow the club on social media as well.
Great, thank you. And Hal, Kelsey, Tanner, this has been extremely informative for those of us who have followed the issue, for those of us who are new to the issue. I think that's one of the fundamental goals of this club, is to recognize the role of freedom of religion as a fundamental human right, and trying to empower people to access that wherever they are in their informative journey, right? There's a lot to learn. There's a lot of ground to cover, especially in the United States. But hopefully those of you who have joined us tonight realize that there's many access points through Congress, through the Trump or Biden administration, through Judge Amy Coney Barrett if she is nominated to the Supreme Court. So thank you. Please follow us on Facebook and join us in our next event. We'll be posting the date and time soon, which will kind of expand on this discussion and will shift to an international sphere. How does domestic policy now play out on the international stage? So thank you again to our speakers, and join us next time.